The Williams Act protects shareholders from hostile takeovers by regulating tender offers. In Brascan versus Edper Equities, the Southern District of New York considered the meaning of the term tender offer. Brascan Limited was a Canadian company traded in Canada, the United Kingdom, and the United States. Edper Equities Ltd, a minority shareholder, wanted to acquire majority control of Brascan. Initially, Edper approached Brascan with an acquisition offer, which Brascan rejected. Nevertheless, Edper was still determined to acquire a dominant stake in Brascan. Due to Canadian securities regulations, Edper couldn't purchase the necessary stock on the Canadian exchange. Instead, Edper consulted James Connacher, the president of Gordon Securities, on buying Brascan shares on the American Stock Exchange. Gordon contacted Brascan's major shareholders and communicated to them that if 3 to 4 million shares became available, Edper might pay a premium price for them. On April 30th, Edper wound up buying 3.1 million shares. At the close of the day, Canadian officials required Edper to issue a press release stating its intention. Edper announced that it had purchased Brascan shares but didn't plan to buy more. The next day, Edper purchased another 3.2 million shares. Brascan obtained an ex parte restraining order preventing Edper from making additional purchases. Brascan moved for a preliminary injunction, arguing that Edper had violated Section 14E of the Williams Act.